Hello everyone and welcome to this video tutorial in which we're going to be looking at a contract law exam question, and today we're focusing on offer and acceptance. So let's start by looking at the mini scenario that we've been given here. So the facts are these. Megan wanted to buy a new laptop. She went to Currys and saw a laptop that she liked. It had a price sticker on for £550. Megan asked a salesperson, Harry, whether the price could be reduced. Harry said no. Megan then asked Harry how much the laptop would cost if she gave her old laptop in part exchange. Harry said £540. Megan said, I'll give you £535. Harry said that he would accept £535 if Megan took out the accident cover for £10. Megan did not want the accident cover, so she said, OK, I'll give you £550. The laptop had just been sold to Kate. And you're being asked to discuss whether there is a contract between Megan and Harry. And to do that, of course, you would have to be applying your knowledge of offer and acceptance to this interaction here to see whether a valid contract had been made at any point. And it's good practice when you've got a scenario in the exam to start highlighting what the key issues are. So the first thing that really jumps out is that this laptop has got a price sticker on it for £550. So hopefully there you will be thinking about, is this an invitation to treat or an offer, and the case of Fisher and Bell. And then when Megan asks Harry whether the price could be reduced, I'm thinking that this is just looking like an inquiry. There's no offer that's happened yet. We've then got Megan asking how much the laptop would cost if she gave her old laptop in part exchange. So this looks like it's a request for further information, and Harry says £540. So we've got an issue here to discuss whether that's merely a statement of information, it's not actually an offer, or is it an offer at that point? That's something we would have to discuss. If it is an offer, when Megan says, I'll give you £535, that would be a counter offer which cancelled out, if you like, that offer of £540 if we think that that is an offer rather than a minimum statement of price. Alternatively, if that's just a minimum statement of price, this is the first offer that occurs when Megan says, I'll give you £535. If that's the first offer here, Harry then says he's going to accept that if she takes out the accident cover for £10. So again, that would be a counter offer, cancelling out that original offer from Megan of £535. Megan then says, OK, I'll give you £550. So what Megan's trying to do here is she's trying to accept the original offer, if you like, of £550. But of course, the original offer we know is going to be an invitation to treat rather than an offer as such. But even if it was an offer, all the exchanges, the offers that have happened since would have cancelled out the original offer. So they're the issues that jump out. Next, we're going to have a look at what structure you should adopt in order to maximise your chances of getting full marks on that. Because as you can see, there's a lot going on, it looks very complicated. So let's look at how you should go about tackling it. So on this slide, I've got instructions for you on how you should go about applying the law on offer and acceptance to a scenario. And you should use the IDEA structure. And each letter of the word idea stands for a different step that you need to take. So I stands for identify. So the first sentence in your answer, you should identify your claimant using their name. And you need to say that your claimant, in our case, Megan, needs to prove that there's a valid offer and acceptance to show that there's a contract. And you then need to define the area of law that you've just identified as being relevant. So we've identified offer and acceptance, so we need to define what an offer and acceptance is. So an offer is a statement of willingness by the offeree to enter into a legally binding agreement, and the contract is formed when these terms are accepted. You then need to explain that definition using your cases, and you need to consider things such as invitations to treat, statements of price, the rules on certainty and communication, whether there's unconditional acceptance or counter offers. You can talk about communication of acceptance, battle of the forms, postal rule, and consider modern methods of communication as well. And your final step, A, is to apply all of those rules that you've explained back to your scenario. Now, the easiest way when you first start out answering offer and acceptance scenarios is to structure it exactly like this. So you I, D, E, and A. So you have a big chunk of explanation and then a big chunk of application afterwards. However, it's better practice really to explain a rule, apply it back, explain a rule, apply it back, so that in essence you've got EA, EA throughout. But for the purposes of this video, I'm structuring all the E together and all the A together at the end. But if you explain a rule and immediately apply it, it means that if you run out of time in the exam, you've not cut out and lost all of the application marks for the question. Okay, so on this slide, I've gone through a bullet point answer to the Megan scenario so that you can see how to go about answering it. Now you'll notice that my answer is very bullet pointy so that I could fit it all on this slide, and I've used abbreviations such as M and H, but of course in the exam you need to be writing in full sentences. You can use abbreviations like that, but you should write the name out fully the first time with the initial in brackets afterwards so that the examiner knows precisely what you're referring to. So I've started off by identifying that there'll be a binding contract between Megan and Harry if there's a valid offer and acceptance. And I've defined offer and acceptance in this way. An offer is a statement of willingness by the offeree to enter into a legally binding agreement. The contract's formed when these terms are accepted. And then you can see I've then explained all of the key rules on offer and acceptance using cases. So an invitation to treat is not an offer. That comes from Partridge and Crittenden, Fisher and Bell. You could talk about Carlyle and Carbolic Smokeball as well. Notice that I've just listed them here for the purposes of this video, but you should outline very briefly some facts that illustrate the principle from each of the cases. You could talk about the rules on auctions using British Car Auctions or Harvella Investments for tenders, and then talk about statements of price not being an offer, Harvey and Facey. And that case is particularly relevant for this scenario because it looks like when Harry was telling her what price he would accept if she did a part exchange, that very much looked like it wasn't an offer, it was a statement of his minimum price he would accept. We can talk about the fact that the offer must be communicated and it has to be in certain terms, but that the offer can be revoked at any time before it's accepted, Routledge and Grant. But of course, that revocation must be communicated to the other party, Byrne and Tienhoven. The offer can lapse. And then I've gone into acceptance here. So acceptance must be unconditional, Hyde and Wrench. And you would talk about what happens there. This case again is very relevant to our scenario because there seem to be lots of things going on with Meghan and Harry where there seem to be counter offers rather than an unconditional acceptance of an offer. Requests for further information and not offers. Again, that looks relevant to our scenario because Meghan asked what the minimum price would be. Acceptance has to be communicated, and I would outline the various specific forms of acceptance and the postal rule. Although they don't really apply to our scenario, it's still good to demonstrate that you know them to the examiner. Now, as I said on the previous slide, the better practice would be to explain a rule like an invitation to treat is not an offer, and then immediately apply it to Meghan and Harry. So if we were doing that, we would say an invitation to treat is not an offer, Fisher and Bell. So therefore, the laptop with a sticker on it is an invitation to treat and not an offer. And then I'd explain my next rules and apply it back. But you can see that for the purposes of making this clear, I've got my explanation here, my application all together at the end. I've then gone on to say that when Meghan asks for a reduction in price, it's merely an inquiry, there's no offer yet. Harry stating no has no legal effect because, again, there's no offer yet. Then Meghan asks how much for part exchange, and this is a request for further information. Now, you can argue it either way and you will still get credit. So I've put here that this is a request for information resulting in an offer by Harry of £540, but you would get equal credit for saying when Harry says £540, this is actually just a statement of minimum price he would consider rather than an offer per se. When Meghan then says £535, because of what I've said here, that would be a counter offer and ends Harry's offer of £540. Notice that whichever way you go with a particular area of the scenario, if you've said it's an offer, that would make this a counter offer. Whereas if you've said that's a statement of minimum price, Meghan's statement of £535 would be the first offer. Both answers are correct because remember, this is going to be a matter for the court, a matter for the judge. But as long as you're applying the law in a way that it could be interpreted and following through the logic, you'll get the marks. So based on what I've said here, if Harry's £540 is an offer, when Meghan says 535, this is a counter offer, ends the offer of £540. When Harry says 535 plus accident cover for £10, this is going to be a new offer based on what I've said previously. Meghan then makes a new offer of £550 because although Meghan might think at this point that she's accepting an offer, even if there was an offer of £550 originally, this sticker, we know it's not, it's an invitation to treat. She can't accept this offer anyway, even if it was one, because all of this discussion has resulted in lots of counter offers which have the effect of destroying the original offer. And there's no apparent acceptance from H of this offer of £550. So the fact that the laptop was sold to Kate, well, that's just tough luck on Meghan. They didn't have a valid contract at that point. So I would conclude by saying that there's no valid offer and acceptance in this interaction, so therefore there's no contract. So I hope that's been helpful and I hope that makes sense. Thanks very much for watching this video. Remember that I do have other videos on my channel which go through all of the law on offer and acceptance, as well as other contract law areas if you need some refreshers. So please have a look at them. And if you can like, subscribe and share, it really helps me to make new content for you.